Hey everyone, I'm Matt Dolan with Dolan Divorce Lawyers in Connecticut. And today I'm going to talk about the child support language you're going to want to have in your divorce agreement or proposed orders to a judge if you're having a trial or hearing. So let me share my screen. And we had a separate video that kind of talks about child support and how it's calculated and how it works. So if you haven't seen that video, I would suggest finding it and watching it because that explains child support. And this video is more just showing the specific language of how you'll want to write it up in an agreement or proposed orders. So first you want to write the weekly amount. So the father shall pay the mother. Obviously it can be the mother paying the father, but one paying the party paying the other blank per week in child support, this amount is in substantial compliance with the Connecticut child support guidelines. So normally child support is pursuant to the child support guidelines, which are this form. And a whole bunch of income is inserted into this form, which you can either do in family law software if you're an attorney, or if you're a self-represented party watching this video. The people at the courthouse and the family relations office, they can help you fill out these child support guidelines. And ultimately they will result in a weekly presumptive child support number based on income, number of children, etc. So you put the weekly amount. And it isn't necessarily in compliance with the Connecticut child support guidelines. You could have a deviation from the guidelines, which again, we talk about in our other video. So if you are deviating, you'll want to put which amount is a deviation from the Connecticut child support guidelines based on the shared parenting. These are some examples of deviations. So shared parenting plan of the parties, extraordinary travel expenses of the father that the father has to incur to exercise parenting time with the mother. That's, if father lives in Connecticut, mother lives in Florida, and he has to travel to Florida to see his child. That might be a reason for a deviation. Or kind of the catch-all, if you have trouble articulating why you're deviating from the Connecticut child support guidelines, you might just put the total allocation of family support. That's just a vague term that people will insert as kind of a catch-all. So that's the weekly amount. Now, in addition to child support, there are certain extra expenses that people have to contribute to. So the common ones are unreimbursed medical expenses and work-related childcare expenses. So childcare expenses that the custodial parent has to incur if they, have to work and put their child in daycare. And again, the percentages are part of the child support guidelines. So the guidelines will show a weekly child support amount, and they will also show the percentage that each party has to contribute to these expenses. And again, you can deviate from those, but the guidelines have a presumptive amount. So you'll just want to put that the mother shall be responsible for blank percent and the father shall be responsible for blank percent of work-related childcare expenses and unreimbursed medical expenses. This obligation and then you want to put how long you want that obligation to extend. So the norm is for it to go for so long as there is a child support obligation, which is, usually till 18. It can extend until it can extend while the child is still 18 if they are still a high school student, but it can't go beyond age the 19th birthday. Although there are certain circumstances where a child has disabilities where it can go beyond 19, but we don't need to get into that here. So you just want to put, for these extra expenses, you can by agreement have them, extend. You might say that they're going to be paid until the child is 21 years old or 23 years old for so long as the child is a full-time student. So you can kind of tailor that language however you want beyond the basic child support term. Then in addition to childcare and medical, you'll also want to deal with extracurricular activities. So sports and, camps, although camps is usually childcare, but the most common thing is sports and other activities, in musical instruments, stuff like that. So you put that the mother shall be responsible for a certain percentage and the father shall be responsible for a certain percentage of extracurricular activity expenses, consent for which shall not be unreasonably withheld. We usually put this language in because, sometimes if and you actually normally want to put of mutually agreed upon extracurricular activity expenses, consent for which shall not be unreasonably withheld. So sometimes, one parent might be a total jerk and they just refuse every extracurricular activity expense because they don't want to pay for it. So you want to put language in where, the parties can't be unreasonable. So, if you have that situation where one parent is just saying, I'm not paying for anything, you can bring that person to court and say, hey, they should have to reimburse me because they're unreasonably withholding consent. So these percentages, you can do them in the guideline percentages, or you can do, a 50-50 split of extracurriculars. These can be tailored however you want. And then again, usually these extracurriculars usually end around, when the child's 18, but you can extend those beyond as well, through college or however you want. And then you'll usually want language in there that talks about how the expenses are reimbursed. So the standard language used is that either party incurs any expense pursuant to this section, they shall provide the other party with documentation of the expense within 7 days of incurring the expense. And the party who receives this documentation shall then reimburse the party who paid the expense within 7 days of receipt of the aforementioned documentation. So that's kind of the standard child support language. Another thing that you might want to insert here is that child support shall be paid by automatic wage withholding. That way, if you can have it set up to automatically be taken out of the obligors. So the person who's paying child support, it's automatically taken out of their pay. So that might be another thing you want to insert there. But those are the basics of the child support language you're going to want to have in a divorce agreement or proposed orders. And as always, if you have any other questions, feel free to reach out to our office. We'd be happy to answer them.